listen, you should be planning usually these. Take those down. Thank you. Thank you so much. Check.
The Honor, may please score.
Yes, sir.
Madam Court Reporter. Citizens. Ladies and gentlemen of our jury, good afternoon. When I spoke to you last week, I talked to you about being in the 3% just because of you being here and giving your time. And now we're here almost 2 weeks later. Very few cases go this far, so I'm not sure what percentage that puts you on. But suffice it to say, it's been a great sacrifice. And on behalf of the defense team, I want to thank you for being here and thank you for your time. Folks, Sidney Moore sits here today. You see his families there behind you. You've probably noticed that they haven't been here a lot of times this week because it's difficult to imagine being here, fighting for your freedom, and then having to look back at everything that you may be missing. And so to try to keep it together, to try to get through this process, he had asked that they stay home. But they're here to support him today, and we want you to know that all of us thank you for your time and for your commitment to do what you're about to do. And you're about to make a big decision, an important decision. And your voice, each and every one of you, you're about to retire to the jury room where what you've seen, what you've heard, needs to be heard. And I think sometimes that gets missed in jury deliberations. We have 12 jurors for a reason, not 1 or 2 or 3. When you get back there and begin deliberating, each of you need to make it known how you view this case, because you all come in with different backgrounds, different experiences, you see things differently, and no one person's view or view of the evidence is superior to the other. And once you have your view heard, you're going to respect those views of others and take it into consideration as you begin deliberating the evidence in this case. Each of you are going to have to answer that question for yourself. Has the state proven and met its burden of proof to actually explain to you what happened to Heather Elvis to the exclusion of all other possibilities? And I submit to you that as we review the evidence, we're going to see that they've not met that burden. And when you review and you come back, this decision that you have to make, it's a final decision. I think that's important to note. You know, if the judge makes an error of law, he does something wrong, you can appeal that. But your decision, your ruling on the facts is final, and nobody can appeal it. That's a power that we only give a jury. We don't give that kind of authority to anybody else in our society. And so as we start beginning to recount what we've heard, I want you to think about what we've got. That is that the state is asking you to trust in their theory of this case. They're asking you to trust in a theory. Like we've said over and over, this is a circumstantial case. They ask that you trust that there are no other explanations for what happened other than those that implicate Sidney's guilt. So how do we know whether or not we can trust this theory or not? Well, we use the same ways to evaluate trust in this case like we do in any other case. I think probably the best example I heard was When I first started practicing law, I was over in Williamsburg County, and I was preparing some documents for an old man that was a farmer and a logger. And I knew him well enough to know he had put a couple kids through school, but I didn't know him well. And so when he came by to sign some documents, I slid it over to him, asked him to read over those, asked him if he has any questions. But when he paused and looked back at me, I'd seen that look before. If you've seen it once, you notice it any other time. The old man couldn't read. It was one of those deals where he kind of looked at me and looked back, and he kind of had that, maybe that embarrassment feel on him. Maybe I was looking down on him. But I wasn't looking down on him. I was in awe of this guy. And I just kind of slid back and said, man, how'd you do it? How'd you get through the day? How do you get 2 kids through college? How do you do all this not being able to read or write? One of the things I asked him was, how do you know who to trust? How do you know what's going on? And he told me that to determine who to trust, what to trust, show me what they value. Show me what they think is important. And if those values match my values, then I'll tell you if that's somebody I can trust. And so as we go back through the evidence, we're going to look at what the state has decided to value, what they've decided to think is important, and what they haven't. And we're going to determine whether or not we can trust the state's theory of the case. Essentially, we start off with trusting the state's belief that Miss Elvis was pregnant the night she went missing. This is the foundation of the case. Make no mistake about it, because that's the motive. It's like a house. Everything is built from this fundamental principle of pregnancy. They ask you to trust that this is the case, but they don't value the fact that nobody has taken that stand with any first-hand knowledge that that was the case. We've heard from 2 witnesses, one her roommate, another her supervisor at work that couldn't confirm it, had no discussions about it. There was a pregnancy test in mid-October, and by mid-December, by all accounts, this is their word, she's back to normal. There's been no follow-up doctor's appointments. There's been no second test. We heard that she had a period in December, but everything is to the contrary, that Miss Elvis is pregnant at this point. There is nothing showing it whatsoever, yet they ask that we trust that this is the case. And that's how this entire theory is built upon. And they go even further. They say, well, there's this pregnancy test that we don't have a picture of, but we know it was there. We ask that you trust that it was there. And the implication is that, well, at some point that night, she must have met up with Sidney and got this test. But the problem with that, folks, is those cell phone data never put them in the same place at any point that night. And they have an excuse for that. And that's a common theme that we're going to see throughout this case, is that when the evidence either doesn't match up, or for some reason they don't have evidence, then they either make up an excuse, or they try to shift the blame to the defendant. But folks, they've got the burden of proof, not the defendant. I've never seen a case where we spend more time, more witnesses, talking about why they don't have evidence than they do presenting their own evidence. I can't recall any case where the number of witnesses to explain away the lack of the state's evidence is that outnumbers their own witnesses. We're asked to, one of the things that we told you about in openings, and again, we didn't have to prepare an opening statement, but when we did, we came in, we told you, we got some problems with this case. One of our problems is that we think the police developed a sort of tunnel vision on Sidney very early on, and that there's other questions that probably should have been asked, needed to be asked, because we're now 2,030-some days later, having had all this investigation, but the books were closed within 2 months following her disappearance. That's how much time they spent investigating before they decided to close the books and charge Sidney. And a perfect example of that is the testimony of Stephen Schiraldi. Now, this was the last person known to see Miss Elvis in person. And maybe we get a big enough screen, but I want you to go back. Ms. Al can provide you with any transcript, any testimony that you want. This is the last person that's known to see Miss Elvis in person. And his mother gets on the stand and says, you know what? Yeah, I spoke to him. I saw Miss Elvis, said, have a good night. We'll see you later. And I can only presume that that was his alibi, excuse me, that the police relied on. But what did Stephen Schiraldi say? When Stephen Schiraldi took the stand, and again, she'll provide you with a transcript, he said, no, I didn't speak to anybody. I didn't see my mom. We didn't communicate. I think she was asleep. Now, I don't know if Mr. Schiraldi had anything to do with this. I would hope he didn't. But I can tell you this. The last person to see her alive that we know, without question, to see her alive, has no alibi for where he was between midnight and 6 a.m. The police did not, all this location data, all these cell phone experts and ping and towers and all of this, they never utilized any of that for Stephen Schiraldi. They didn't say, all right, well, I understand what you said, Mr. Schiraldi, but we're just going to check out your story. Let's see where your cell phone worked, see if it matches up. They never said, you know what, Mr. Schiraldi, we understand what you're saying, but I tell you what, why don't you give us a fingerprint or a hair strand, and we'll just check out. And if it showed up in the bedroom or somewhere else, then that would have required a little bit more follow-up. But they did none of that. This is what the state's asking you to value. Contradictory testimony, one right after the other. And so why didn't they do it? Well, what we've heard is that within the first 24 hours, the initial investigator, he's immediately at the Moore residence with not one, not two, but 3 officers. Within 48 hours, Mr. Moore is at the police station, his vehicle's at their house, and they've already arrived at his personal residence. They've done none of those for Stephen Schiraldi. We've heard about Jerry Stevens. We've heard that the text communications was that she was going to come over the following night. Okay, maybe she did, maybe she didn't. Was there any location data provided to his whereabouts? We heard that he says he was at a friend's house off of 707. So wouldn't it be worth the little bit of effort or energy to say, all right, well, we're going to use the same resources, the same technology that we've used to try to prepare a circumstantial case against Sidney and see if maybe we can exclude some of these other people. But they didn't do that. They didn't do any of that. We're asked to believe the testimony of Dominic DiMarino. Folks, Dominic DiMarino, he says that he saw a picture from Sidney's cell phone. Look at all the evidence. We've got all the cell phones and evidence. It's not there. And this is one of the few places where they don't have an excuse for why they don't have that. But we don't see it. He didn't tell anybody about it. He didn't find it unusual. He didn't take any action. Only thing he did was later tell his mom that, you know what, I made that up. And yet still, this guy that came out to you in handcuffs and shackles for carjacking, for fraud, that's what they valued in this case. That's the type of testimony that they believe to be important. And let me tell you this. We've heard testimony that, you know what, sometimes direct evidence may not be as reliable. People that see things, they misremember, or, they don't have good vision. Folks, I gotta be honest, I think that's a little disingenuous, because I guarantee you, if they had eyewitnesses to see something, they'd be taking that stand, because they had Dominic DiMarino take the stand. Mr. Helms wants you to believe that because he put his hand on this Bible and swore that he wasn't lying, that we can take it as such. Folks, this is a man that breaks into your cars at night, steals from you, lies. He's not concerned about this book. He lives his whole life in complete opposition to everything in this book. That's the type of testimony we've been asked to value and find important in this case, and to trust in this case. We're asked to trust that Sidney Moore actually went to Peachtree Boat Landing on the night of the 17th or the other 18th. We're asked to trust in Grant Fredericks. They don't value the testimony of Bruce Koenig, an actual career scientist, head of the FBI lab, that says, you know what, you can't do what he's trying to do. And that's consistent with what the MATE team did. They don't value that. But we're asked to trust that this is the case. You know, we heard from Mr. Koenig, and he talked about all the famous cases he had and all these things he was involved with, and he said, you know what, what Mr. Fredericks is trying to do, you can't get there. Just like the MATE team said, just like all the evidence did until he was hired well after Mr. Moore's arrest. And you can look at the video quality whenever you get back there if you want to go through the slides. Like he testified to, this is a very poor quality video, but as you go through it, if there's any discrepancy, if there's any inconsistency, then it's obviously not a match. You don't need anything further. You know, we've been asked to trust that he went to Peachtree Boat Landing, yet after all this cell phone data, days of cell phone, location data, nothing ever puts him at the landing. We're asked to trust that he went and presumably picked up Miss Ellis. But there's no DNA anywhere. And again, they have another excuse. Well, there's a reason for that. Well, he cleaned the car. Folks, you mean to tell me the state of South Carolina, Horry County government, SLED, all the labs we've heard about, all the experts that's been engaged in this case, all the money that's been spent on this case, you're telling me that a handyman with a vacuum cleaner can eliminate all the hairs and fibers and everything else? That he presumably took somebody against their will, presumably held them, forced them in his car, kept them in their car, transported them in their car, and yet in the afternoon with a shop vac there at his house, he eliminated any trace of physical evidence whatsoever? Because remember, we didn't hear anything about industrial cleaners. We heard nothing about bleach or about anything else. We just heard that he was standing there at his house, vacuuming his car. And that's their excuse for why there's no DNA in that truck. But folks, the truck didn't go to the landing. That's why there's no DNA. Because she wasn't in that truck. We've talked a lot about the navigation data. This is another example where they're spending time calling witnesses to explain away why they don't have that evidence. And we get a sampling, a piece of data about this SD card. But what did we also hear? That because they waited 2 years to actually get the information out of the box, we wouldn't have had it anyway. Now, if it was important, if they would have done it closer to the time of the investigation, then maybe they would have had something, maybe they would have had an argument, but they waited until we knew you wouldn't be able to get any data at all anyway, and then they try to hold it against Sidney. He's not in possession of that car. After February 21st, the state takes possession of the car, and we hear that eventually he loses it, and it's at another owner by the time it gets involved. But it's another excuse for why they can't put the two together, for why they can't answer the questions that are necessary in order to find guilt in this case. Folks, we've talked about a lot of different legal standards. You've heard about probable cause, and that's what they had 2 months after the disappearance. Probable cause just means enough to have an arrest. And they met that, and they had an arrest, and for the next 5 years, 6 years, they've been trying to gather more evidence, trying to see what they can get. And they've just been doubling down on the same problems that they've had up until this point. Some of you may have served on a civil jury, and I do civil cases, and you may have heard about the preponderance, that the scales of justice tilt ever so slightly. But there's a reason this is different than a civil case. In a civil case, we're just talking about money. Here we're talking about somebody's life, somebody's freedom. And in a civil case, you get to conduct your own investigation. Ms. Livesey decides to sue me, pays a $100 fee, well then I can conduct depositions, I can depose other people, request records from third parties. You don't do that in a criminal case. It's illegal to conduct a parallel investigation in a criminal case. You're forced to respond to what the state presents, to what the state has uncovered. And that's what we're doing in this case. And after all the evidence accumulation, after all the effort they've done, they've now come to you and asked that you believe that they've met their burden to beyond a reasonable doubt, the highest burden we have in the legal system. And in so doing, they're saying that they've excluded all other reasonable possibilities. But folks, they can't do that when their first couple of witnesses are contradicting each other, when they have no reason why they didn't do this and they didn't do that. They can't explain that away. The standard isn't, was Sidney Moore, did he do something suspicious, or do we have questions about him? That's not it. When you go back and begin deliberations with the 11 other jurors, and you've got a question, something that's not been asked, and the state hasn't answered that question, all of them, each and every one of them, then they have not met that standard. Because we're going to talk about what it means to hesitate to act. The judge is going to instruct you that reasonable doubt means any time that you get that feeling, that hesitancy to act. And I think probably the best explanation is what we all saw during jury selection. There were a number of people that stood up when asked, if they could be impartial. They stood up and said, well, Judge, I don't know. And what did Judge Dennis do? He said, that tells me all I need to know right there. That if you have that feeling in the jury room, that, not sure, that is the hesitancy to act. And if you do that, if you have that feeling with your experiences, your voice, your obligation is to say, not guilty. One of the difficult things that we have in asking you to go back and deliberate something like this is that so often in our daily lives we choose one side or the other. We choose categories. We're not often looking at specific examples. Left or you right, or red or blue. But if you go back there in your deliberations and you say, you know what, I think the police maybe made some mistakes. I think they didn't answer some questions. You're not anti-law enforcement. We're all pro-law enforcement. But we understand that people make mistakes. We understand that people maybe rush things a little bit. We understand that sitting now with the benefit of hindsight that maybe, there were some things that weren't done. And if you decide that the state hasn't met its burden of proof, you're not anti-prosecution. You can tell Ms. Livesay and Mr. Helms, thank you for the service that you've done, but we're just not comfortable with it. We don't think there's enough there. And if your decision at the end of this case is not guilty, then your prayers for Heather Elvis and for her family aren't any less valid. They're not any less true, any less genuine. Before I came to the courthouse today, I heard on the radio there was an issue about, I think it was an Iranian tanker, and the headline kind of caught my attention because it said, the president has said that we have circumstantial evidence that, I believe it was Iran, had instituted this attack. But I can tell you, as soon as I heard that, guess what? It's not going to be a war, because we don't go to war on circumstantial evidence. And folks, we don't go to war on circumstantial evidence, and we don't send people to prison on circumstantial evidence. And that's what we have in this case. And I want to talk about one last thing, and it's difficult to talk about. Folks, throughout the course of this trial, we've heard that, Miss Elvis is gone. She's not coming back. And what is that? That's not a kidnapping charge. That's something more serious. And folks, we talked about the hesitancy to act. We're asked to trust in the state's theory, the state that's tasked with seeking justice, with pursuing charges, but they're holding back. They've hesitated to act on this case. They've brought this as a kidnapping. case, and a conspiracy to commit kidnapping. Folks, the case has been a lot of excuses for the fact that the evidence just doesn't fit, and that Sidney Moore has not been proven to have anything to do with Miss Elvis's death. As you go back to the jury rooms, I just ask that you weigh those things that we talked about. If you need to hear something or you need to see something again, any of this that's come in can go back with you to the jury room. But I just ask that each and every one of you utilize your own personal experiences, what you've heard and what's been important to you, and make those voices heard as you begin your deliberations. Thank you.